Welcome to the Mandated Reporter for Educators. Your role as a mandated reporter is critical in helping us achieve safety, permanency, and well-being for the children of Connecticut. In order to promote and maintain that safety, permanency, and well-being of our children, the Department of Children and Families has adopted a vision that our contacts with families and providers should be respectful and strength-based. A partnered approach to our work relies on holding judgments lightly and listening. In the legislative session of 2011, a significant piece of legislation passed that impacts the role of educators and school personnel in reporting suspicions of child abuse and neglect. Public Act 11-93 was drafted as a result of a joint report of the Office of the Child Advocate and the Office of the Attorney General, which identified significant flaws in the reporting of those suspicions. This act encourages mandated reporters to fulfill their legal responsibility of reporting their suspicions of abuse and neglect, streamlines the department's investigative process, and clarifies the information sharing that is allowed in cases of alleged abuse and neglect. The legislation also specifically calls for educators and school personnel to be trained in the mandated reporter process and sets standards for background checks involving potential school employees. Public Act 11-93 is wide in scope and calls for collaborative efforts between the Department of Children and Families and the Connecticut State Department of Education. Cross-references and notifications relative to the DCF Central Registry, a database of those substantiated for child abuse and neglect and deemed to be a danger to children, are components of the law, as well as an expansion of mandated reporters in school systems. The Public Act stipulates timeframes for training of new staff and retraining of staff hired prior to the passing of the Act. The Department of Children and Families will maintain a database and investigate mandated reporters who fail to or delay a report of suspected abuse or neglect. The law also stipulates that DCF will report to the Chief State's Attorney instances of mandated reporters delaying or failing to report those suspicions. The legislation allows for record sharing between school districts and DCF when a school employee is suspected of abuse or neglect. Our goal of this training is to provide mandated reporters with information, keep them informed of their role and responsibilities in reporting suspected abuse and neglect, and take necessary measures to protect them and the children we both seek to serve. The Department of Children and Families is available to hear the concerns, answer questions, and work collaboratively with mandated reporters. The Connecticut General Statutes mandate those professionals whose work involves regular contact with children to report suspicions of child abuse and neglect. The Connecticut General Statutes specify those who are obligated to report their suspicions. This list is reviewed annually by the legislature, and Public Act 11-93 further clarifies who in a school system is a mandated reporter. This information comes directly from Statute 53A-65, subsection 13, and clearly defines who from a school system must report suspected abuse or neglect. A teacher, substitute teacher, school administrator, school superintendent, guidance counselor, psychologist, social worker, nurse, physician, school paraprofessional, or coach employed by a local or regional board of education, or a private elementary, middle, or high school, or working in a public or private elementary, middle, or high school, or any other person who, in the performance of his or her duties, has regular contact with students and who provides services to or on behalf of students enrolled in a public elementary, middle, or high school pursuant to a contract with the local or regional board of education, or a private elementary, middle, or high school pursuant to a contract with the supervisory agent of such private school. The statutes clearly indicate that mandated reporters, in the ordinary course of their employment or profession, must make a report or cause a report to be made to either DCF or law enforcement when they have reasonable cause to suspect or believe that a child under the age of 18 has been abused, neglected, or is placed in imminent risk of serious harm. Reasonable cause is not necessarily certainty. Mandated reporters may have reasonable suspicion that abuse or neglect has occurred as a result of what they see, what is told to them, or knowledge from professional training or experience. Mandated reporters are to make or cause a report to be made, and the Department of Children and Families will complete the necessary investigation or assessment. The statutes of the state of Connecticut also define what constitutes an abused child in Section 46B-20. Those children must be under the age of 18 who have had non-accidental physical injuries inflicted upon them. Many times, children provide explanations for those injuries. However, in some instances, the history or account provided are at variance with those injuries noted. This also constitutes abuse and should be reported. Other forms of abuse include malnutrition, sexual molestation or exploitation, deprivation of necessities, emotional maltreatment, or cruel punishment. Many times, sexual abuse is not directly reported by children. It is important to be aware of some of the potential indicators of child sexual abuse. Some of the physical indicators of child sexual abuse include unexplained injuries or complaints of pain in the genital, vaginal, or anal areas. If a child under 13 has a venereal disease, a facility is obligated to make a report to the DCF care line. Pregnancy may also be an indicator of child sexual abuse. There are also emotional and behavioral indicators that may suggest the presence of child sexual abuse. These indicators do not in and of themselves categorically indicate child sexual abuse has occurred, and their presence may require a discussion with a child to ensure their safety and well-being. The age of consent for sexual activity in the state of Connecticut is 16 years of age. There are instances where the age of consent is increased to age 18. These situations include the following: when one person is a guardian or responsible for the general supervision of the other, when one person is a coach or instructor outside of a school setting and the other person is being coached or instructed, and when one person's professional, legal, occupational, or volunteer status create a power differential over the other when the older person is at least 20 years of age. There are instances where the age of consent for sexual activity is irrelevant. The sexual activity in these instances criminalize those relationships. These instances are directly applicable to school employees and include when one person is a school employee, excluding post-secondary schools, and the other person is a student, and when one person is a coach or instructor and the other person is a student. The Governor's Task Force on Justice for Abused Children has created a training designed to assist schools on how to report and respond to allegations of child sexual abuse by obtaining only minimal facts. This reduces potential trauma of re-victimization of children by having to tell their account of child sexual abuse multiple times. The contact agency for this training is the Connecticut Children's Alliance. Neglect is also defined in the Connecticut General Statutes and includes children who have been abandoned, are denied proper care and attention, or are permitted to live under conditions, circumstances, or associations injurious to their well-being. The exposure to substance abuse, domestic violence, or parents with mental illness that has a negative impact on children can constitute neglect. Issues such as inadequate supervision, clothing that is inadequate for the weather, exposing children to illegal activities, or the failure to maintain a safe living environment are other examples of neglect. Neglect allegations are more prevalent than abuse allegations. While abuse represents an action against a child, neglect is the omission or a lack of action that compromises the child's safety or well-being. A type of neglect that is directly related to schooling is that of educational neglect. When parents or guardians fail to enroll or send their children to school, do not receive home instruction, or do not ensure regular school attendance, educational neglect can be reported to the care line. Medical neglect occurs when a person responsible for a child's care fails to obtain necessary or indicated care for their children, or when medical care is withheld from disabled infants with life-threatening conditions. An example of medical neglect would be a parent or guardian who does not provide insulin on a regular basis to their diabetic child. Medical care or treatment for a diabetic is necessary and indicated. The failure of a parent or guardian to seek routine pediatric or dental care does not constitute medical neglect. The department fields many questions regarding when it is appropriate to leave your child alone and unattended. There is no statutory age at which a child is deemed appropriate to be left alone. However, Criminal Statute 53-21A does stipulate that a parent, guardian, or custodian cannot leave a child under the age of 12 in a motor vehicle or in a public place for a period of time that may jeopardize their health or safety. The department investigates and assesses reports where the reported abuse or neglect of children has been caused by the persons responsible for their care or by people who have been entrusted to care for or given access to those children. There are several people who fall under the category of persons responsible. These include parents and legal guardians, foster care providers, daycare staff, and residential treatment staff. A person responsible may entrust the care of their child or allow access to their child by another person. This person becomes an entrusted caretaker. Some entrusted caretakers include school employees, babysitters, tutors, coaches, relatives, or youth leaders. While these people are not legally responsible for the child, they are entrusted to care for them. In instances when an entrusted caretaker is suspected of abusing a child, a mandated reporter is to contact the DCF care line to report their suspicions. State statutes indicate that a mandated reporter should make their report to the DCF care line as soon as practical, but no later than 12 hours after the abuse or neglect has been identified. The mandated reporter should contact the DCF care line at 1-800-842-2288 or contact law enforcement. Following the call, a mandated reporter is required to fill out the DCF 136 Report of Suspected Child Abuse and Neglect form available on the Internet. This form should be completed and sent to the DCF care line within 48 hours. This process must be done sequentially, with the oral report first, followed by the written report. Mandated reporters are legally obligated to make referrals to the DCF care line if they have reasonable suspicion to believe that child abuse or neglect has occurred. It is the responsibility of the Department of Children and Families to conduct the necessary intake, investigation, or assessment. Mandated reporters do not need to conduct an investigation prior to making a referral to the care line. When making a report, having as much information as possible will allow the care line to make a more informed decision as to whether the information meets the statutory requirements to be accepted as a report of child abuse and neglect. Much of this information is found on the DCF 136, and it may be helpful to fill out the DCF 136 prior to making the oral report. When making an oral report, State the reason the alleged perpetrator is suspected of causing the abuse or neglect. Indicate any prior knowledge of instances whereby the alleged perpetrator caused injury. These factors are taken into consideration by the care line. This helps the department in making an informed decision concerning the safety of the children involved. Please make note of the contact information for the DCF care line. This information is also contained on the DCF 136 Report of Suspected Child Abuse and Neglect form. The care line is available 24 hours a day. There are certain times when DCF will notify law enforcement within 12 hours of receipt of a report. These include serious, non-accidental physical abuse, allegations of child sexual abuse, and fatalities of children. The department works collaboratively with local law enforcement in many of these cases. Confidentiality and anonymity. Mandated reporters are required by law to provide their name when making a report. However, can request to remain anonymous to the family on whom they are reporting. The identity of a mandated reporter requesting anonymity will be disclosed in some instances, including to other DCF employees, law enforcement, court personnel, child care licensing agencies, and directors or superintendents of schools. There are legal protections and consequences associated with reporting or failing to report suspected allegations of abuse or neglect. Let's examine them in the next few slides. So long as a mandated reporter makes a report in good faith or does not make a report in good faith, they are immune from any penalties, be they civil or criminal. However, if a mandated reporter maliciously or falsely makes a report of suspected abuse or neglect, they can incur a fine and possible imprisonment. There are also consequences for failing to report or making a delayed report. Those include a fine and attending mandated reporter training at the expense of that mandated reporter. If a child suffers further or continued harm as a result of the mandated reporter's delay or failure to report, the mandated reporter may be liable for civil damages. If you suspect child abuse or neglect, make a referral to the DCF care line in a timely manner. A mandated reporter who makes a report in good faith cannot be retaliated or discriminated against by their employer as a result of making that report. Criminal and civil penalties may be incurred if an employer engages in such actions. Any mandated reporter must report suspicions of abuse and neglect to the DCF care line. This does not preclude human resources from boards of education from conducting their own investigation. However, that investigation cannot impede the DCF or law enforcement investigation. Differential response is a new and flexible intake and assessment model that will improve the way that DCF responds to families. Differential response is an approach to provide children and families with different levels of service based on the type and severity of the child maltreatment and the needs of the family. All differential response cases meet the statutory criteria to be accepted as a case of child abuse and neglect. This slide will give you an overview of how differential response will work by using two tracks: intake, a forensic investigation track, and assessment, a comprehensive evaluation of what services would benefit a family. Cases with higher levels of risk will be maintained on the intake track, and an investigation will occur, complete with mandated collateral contacts. Investigations focus on whether the allegations are substantiated or not, and whether the alleged perpetrator is a danger to children and needs to be placed on the DCF Central Registry. Cases that have lower risk levels will go on the assessment track. The department will initially be conservative as to which cases meet assessment criteria. Within the assessment track, more input is received from the family. Primary components of the assessment track cases are the presence and development of the protective factors, as well as focusing on the strengths of the family to resolve issues of concern. Cases on the assessment track do not focus on substantiation of allegations, but rather what services can assist the family. There is no central registry component to the assessment track. Cases that are on the assessment track that are determined to have safety concerns can be switched to the intake and investigation track if necessary. The decision as to which track is utilized is made at the care line. This does not impact the mandated reporter, who should still report any suspected child abuse or neglect to the care line. This slide highlights the differences between a case in the intake and investigation track versus the assessment track. Child safety will be assessed in both tracks. The utilization of a differential response system allows the department flexibility and focuses on addressing issues to prevent further involvement in the Child Protective Services system. The department is seeking to partner more with families to help mitigate potential abuse and neglect. Engagement with the family and community service providers is critical to the process, and shared accountability for strengthening families is emphasized. It is the hope of the department to address issues of disproportionality by the use of the assessment track. In Child Protective Services cases, people of color are overrepresented relative to the general population. Many of the issues of neglect may be due to a lack of available services or due to poverty. The department's assessment track focuses on service delivery to ameliorate such issues. In response to several cases involving infant abandonment, the Safe Haven Act was passed. This act allows a parent to surrender the physical custody of an infant aged 30 days or younger to the nursing staff at a hospital emergency room. At the time of that surrender, the parent is not required to provide any identifying information or medical history. The Department of Children and Families looks forward to partnering with the community to strengthen our families. As mandated reporters, you play a key role in this work. Congratulations on completing the mandated reporter training.